Let us pray. Almighty God, who in your wisdom and goodness have appointed the officers and leaders and the count assemblies for the welfare of society and the just government of the people. We beseech you to behold with abundant favor as your servants whom you have been pleased to call to the performance of important tasks in this republic. Let your blessings descend upon us here assembled, and grant that we treat and consider all matters that shall come under deliberations in so just fit and a faithful manner as to promote your honor and the glory, and to advance the peace, prosperity, and the welfare of our country, and of those whose interests you have committed to our church. Amen. Next order.
Administration of court.
Next order.
Communication from the chair.
Next order. Next order.
Petitions.
Next order.
Papers.
Papers to be laid. Honorable Amos Matunda, Member of Congress Assembly, Nyamira.
And I wish to lay a public participation report on the removal of Honorable Amos Nyaribo, the governor of Nyamira County, from office by way of impeachment. I now lay the report.
Thank you. Next order.
Notices of motions.
Next order.
Statements.
Next order.
Motions and bills.
The Honorable Julius Kimomi Matwere, Member of County Assembly representing Manyamatuta Ward.
Honorable Speaker, I move a motion that this county assembly debates and approves the removal of Honorable Amos Nyaribo, the governor of Nyamira County, from office by way of impeachment on the following grounds. 1, gross violation of the Constitution of Kenya and other laws, and 2, abuse of office. I move.
Read the details of the motion.
Mr. Speaker,
Proceed.
Mr. Speaker, whereas the Constitution of Kenya 2010, Article 181(1) provides for the removal of a county governor from office on grounds of gross violation of the Constitution or any other law, abuse of office or gross misconduct, or if there are reasonable grounds to believe that the county governor has committed a crime under national or international law, and whereas Section 33 of the County Governments Act 2012 further elaborates the procedure and grounds for the removal of a county governor, aware that the standing orders of the County Assembly of Nyamira and the standing orders of the Senate provide the procedural framework for such a motion, cognizant of the fact that all state officers are required to act within and in accordance with the Constitution and laws, exercise authority and perform public functions with respect and honor, be accountable to the public for their decisions and actions, and use public funds in accordance with the Constitution and the law. Noting with grave concern that His Excellency Amos Nyaribo, Governor of Nyamira County, has not just strayed, but has galloped outside the confines of the Constitution, brazenly circumvented the laws, grossly violated the Constitution, failed to guard public funds, and deliberately executed corrupt practices in management of county affairs, leading to massive loss of public funds, Mr. Speaker. Now, therefore, I, the undersigned member of the County Assembly of Nyamira, move the motion for the removal of His Excellency Amos Nyaribo from office of County Governor, Nyamira County, by way of impeachment. Honorable Speaker, I now proceed to state the grounds for impeachment and or specific particulars, a narrative of betrayal and the constitutional delinquents, Mr. Speaker. Grounds for impeachment. The grounds below paint a pattern of blatant constitutional disregard and the fiscal impropriety by Honorable Amos Nyaribo, Governor of Nyamira County. Ground 1, gross violation of the Constitution and other laws. Particular 1.1, gross violation of the Constitution of Kenya 2010 and the County Governments Act 2012 through deliberate formal engagement, endorsement and support of an unlawful, illegal, unconstitutional bunge machinery. Whereas Article 1, 10 and 73 of the Constitution 2010 enshrine the principles of sovereignty of the people, the rule of law, and the responsibilities of state officers. Whereas Article 176(1) of the Constitution of Kenya 2010 unequivocally establishes the County Assembly for each county, and Section B2, 7B2 and 14(1)A of the County Governments Act 2012 govern the lawful sittings and procedure of the County Assembly. Whereas Section 6A1 and the third schedule of the County Governments Act 2012 specifies the location of the Nyamira County Government as the Nyamira urban area. Whereas Section 7B2 of the County Governments Act 2012 provides that, except for a sitting of a new county assembly under Section 1, a sitting of a county assembly may be held at any place within the county and may commence at any time as the county assembly may appoint. Whereas Section 32A of the County Governments Act 2012 requires the government to diligently execute the functions and exercise the authority provided for in the Constitution and the legislation. Whereas Section 33C of the County Governments Act 2012 requires the governor to promote democracy and good governance, unity, cohesion within the county. His Excellency Amos Nyaribo deliberately engaged, endorsed, and supported an unlawful, illegal, and unconstitutional bunge mashinani, gazetted by Enoch Okero, by Kenya Gazette Notice number 14229 of 2024, dated the 29th of October 2024. And the appointment of an acting clerk by the Kenya Gazette Notice number 14230 of 2024. There is Annex 1.1/1, despite the knowledge that despite knowledge of the fact that the said Enoch Okero had been removed from office of Speaker by way of impeachment, as is published in the Kenya Gazette Notice of Notice number 14050 of 2024, dated 25th October 2024, as seen in Annex CAN 11/2, Mr. Speaker. The Senate of the Republic of Kenya on 15th May 2025, while considering a progress report of the Standing Committee on Volation and Intergovernmental Relations on the operational and leadership crisis affecting the County Assembly of Nyamira, resolved that, and I quote, the decision and resolutions made by the impeached Speaker and members of the County Assembly that convened outside the gazetted precincts of the County Assembly are null and void, Mr. Speaker. The same was communicated to the clerk of the County Assembly of Nyamira and a copy to the governor of Nyamira County by letter reference number SEN/Resolves/17/2025, dated 22nd May 2025, Mr. Speaker, as per Annex 1.1/03. The impeachment of Enoch Okero was affirmed by the judgment of the High Court at Bomet in petition number E004 of 2025, Mr. Speaker, delivered on the 4th May of June 2025. In paragraph 74 of the said judgment, it was the court's finding that the seventh respondent, in brackets Enoch Okero, the impeached Speaker, ceased to hold office on 24th of October 2024. Further, in paragraph 85 of the same judgment, the court found that any actions or duties performed by the seventh respondent, Enoch Okero, the immediate Speaker, were illegal, null and void, as the seventh respondent neither had the power nor the locus to do so, as shown in Annex CAN/11/04. Whereas the governor and his accomplices maintained that there were court orders stopping the County Assembly from removing Enoch Okero from the office of Speaker, the High Court at Bomet, by judgment in petition number E004 of 2025, delivered on the 4th day of June 2025, settled this matter and held that there was no such order, and that the county was not barred from impeaching Enoch Okero from the office of Speaker, or exercising its constitutional mandate. The same is found in paragraph 72 of the said judgment, where the court held that this court's critical interpretation of order number 2 issued on the 11th of October 2024 by Okwani J was that she issued conservative orders stating the suspension of the seventh respondent as speaker. This effectively meant that the seventh respondent assumed his duties as Speaker of the County Assembly. In regards to order number 3, the judge issued conservatory orders that barred interference of the duties of the seventh respondent as Speaker. Order 3, as worded above, did not mention the County Assembly of Nyamira was barred from impeaching the seventh respondent or exercising its constitutional mandate. His Excellency Governor Amos Nyaribo consistently and deliberately supported the engaged with the gatherings of an unlawful, illegal, and unconstitutional bunge machinery, which conducted its meetings from October 31st, 2024 up to June 2025 in locations away from the lawful and official gazetted premises of the County Assembly and without lawful
Order, Honorable Maker, assume your seat. Sergeant at arms, anybody who has entered the chambers without following the procedure? Order, order, close the door. Order. The respect for the chambers has to follow up to the latter. Sergeant at arms, make sure before you usher in any visitor, you inform him or her of the procedures on how to enter the chambers. Proceed, Honorable Maker. Proceed. This is the house of law, and the law has to be followed.
Thank you, Honorable Speaker. His Excellency Amos Nyaribo consistently and deliberately supported and engaged with gatherings of an unlawful, illegal, and unconstitutional bunge machinery, which conducted its meetings from October 31st, 2024 up to June 2025 in locations away from the law and the official gazetted premises of the County Assembly and without law appointment. Further, the Governor made public pronouncements declaring Enoch Okero and Silvanus Nyamira as the legitimate Speaker and Clerk respectively, while aware that Enoch Okero was duly impeached as per Annex CAN/1, 11, Volume 1. The government's actions to formally engage in those and support an unlawful, illegal, and unconstitutional bunge machinery directly undermines the legislative representation and oversight role of the County Assembly of Nyamira as established by the Constitution of Kenya 2010 and the County Governments Act 2012, thereby constituting a gross violation of rule of law and the principle of separation of powers. Particular 1-2, Mr. Speaker, gross violation of the Constitution of Kenya 2010 and the County Governments Act 2012 and the Public Finance Management Act 2012 by assenting to the Nyamira County Supplementary Appropriation Bill 2024 without the approval of the County Assembly of Nyamira. Whereas Article 175A of the Constitution of Kenya 2010 requires that the county government shall be based on democratic principles and the separation of powers, whereas Article 1851 of the Constitution of Kenya 2010 states that the legislative authority of a county is vested in and exercised by its county assembly, prescribed in an act of parliament. Whereas Section 21(1) of the County Governments Act 2012 requires that the county assembly shall exercise its legislative power through bills passed by the County Assembly and assented to by the Governor. Whereas Section 130 of the Public Finance Management Act 2012 provides for the procedures of processing a county budget, including transmission from the county executive to the county assembly for consideration and approval. Honorable Speaker, the Governor on 26 November 2024 assented to the Nyamira County Supplementary Appropriation Bill 2024 without the approval of the County Assembly of Nyamira, in total defiance to the constitutional principle of separation of power. The Nyamira County Supplementary Appropriation Bill 2024 is not among the business transactions transacted during the morning and afternoon sittings of the County Assembly of Nyamira on 26 November 2024 as per Annex CAN 12/05A and B. The Nyamira County Supplementary Appropriation Act 2024, as assented by the Governor, significantly altered the priorities and the development programs in the original approved budget as per Annex CAN/12/06. Honorable Speaker, this conduct constitutes a gross violation of Article 175A, 1851, 224 of the Constitution of Kenya 2010, Section 1/3 of the Public Finance Management Act 2012, Section 21(1) of the County Governance Act 2012, and the Order number 137(1) of the County Assembly of Nyamira Standing Orders, and the due process of the law, which requires that the county budget be approved by the County Assembly. The same undermined the representation and oversight role of the County Assembly. The supplementary budget was assented to, devoid of a participation of the people and all their representatives. Particular 1.3, Mr. Speaker, is on gross violation of the Constitution of Kenya 2010 and the County Government Act 2012 by appointing Dr. Perry's of the Assembly from among persons who are not members of the Assembly. Whereas Article 259 of the Constitution emphasizes the interpretation of the Constitution, which includes the respect for judicial pronouncements. Further, whereas Section 30D of the Constitution of the County Government Act 2012 requires the governor to appoint, with the approval of the County Assembly, members of the County Executive Committee. Whereas Section 4 of the Public Appointment County Assembly's Approval Act 2017 requires that an appointment under the Constitution or another law for which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with this act. His Excellency Amos Nyaribo appointed Dr. Nyaribo to the County Executive Committee without the approval of the County Assembly of Nyamira, in total disregard of the due process of the law. In response to an inquiry by the County Assembly, the County Executive Committee member for Public Service Management maintained that Dr. Nyaribo is duly appointed as per Annex CAN /13/07A and B. Failure to submit the name of Dr. Nyaribo for vetting and approval by the County Assembly of Nyamira constitutes gross violation of Article 179(2)(b) and 259 of the Constitution of Kenya 2010 and Section 30D of the County Government Act 2012. Honorable Speaker, the Governor has to date proceeded to retain Dr. Nyaribo and supervised her integration into the payroll system since June 21st, 2025, and authorized the payment of her salary and allowances despite clear judicial and senatorial pronouncements declaring all actions of Bunge Mashinani as illegal, null, and void. As per Annex CAN 13/08A and B, Annex CA 11/03, Annex CAN 11/4. The governor willfully circumvented the legitimate constitutional approval process, rendering the appointment unlawful. This action brazenly bypassed the County Assembly, constituting a gross violation of the Constitution and the statutory provisions governing appointments. Particular 1.4 on the gross violation of the Constitution of Kenya 2010, the Urban Areas and Cities Act 2011, and the Public Appointments County Assembly's Approval Act 2017 by appointing Nyamira and the Keroka municipalities board members without the approval of the County Assembly of Nyamira. Whereas Article 10 of the Constitution on National Values and Principles of Governance requires the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Section 14.1 of the Urban Areas and Cities Act 2011, as amended 2019, requires that a board of a municipality shall consist of 9 members appointed by the county governor with the approval of the county assembly. Whereas Section 4 of the Public Appointments County Assembly's Approval Act 2017 requires that an appointment under the Constitution or another law for which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with these acts. His Excellency Amos Nyaribo provided Gazette Notice number 1965 of 2025, dated 30 February 2025, appointed members to the boards of Keroka and Nyamira municipalities without the approval of the County Assembly of Nyamira. In direct defiance of the Constitution of Kenya 2010, the Urban Area Cities Act 2011, as amended in 2019, and the Public Appointments County Assembly's Approval Act 2017, as per Annex CAN 14/09. The approval of members of the 2 boards was not among the business transacted during the morning and afternoon sittings of the County Assembly of Nyamira on 19th November 2024, as per Annex CAN 14/10A and B. The governor has to date retained the state board members in deference of clear judicial and senatorial pronouncements as per Annex CAN 11/03, Annex CAN 11/04. This constitutes a blatant disregard for the rule of law and a contempt for legitimate authority. Honorable Speaker, particular 1.5 on gross violation of the Constitution of Kenya 2010 and the County Governments Act 2012 by appointing the selection panel for the recruitment of the chairperson, secretary, and members of the Nyamira County Public Service Board, CPSP, without the approval of the County Assembly of Nyamira. Whereas Article 10 of the Constitution on National Values and Principles of Governance requires the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Article 73 and 74 of the Constitution 2010 outline the responsibilities of state officers and the principles of public service, demanding objectivity, impartiality, and accountability. Whereas Article 232(1) of the Constitution 2010 sets the values and principles of public service, requiring efficient use of resources, transparent and fair competition and merit. Whereas Section 4 of the Public Appointments County Assembly's Approval Act 2017 requires that an appointment under the Constitution or another law for which the approval of a county assembly is required shall not be made unless the appointment is approved by the relevant county assembly in accordance with this act. The governor appointed a selection panel for the recruitment of the chairperson, secretary, and members of the Nyamira County Public Service Board without the approval of the county assembly of Nyamira. The governor willfully circumvented the legitimate constitutional approval process, rendering the appointments unlawful. The selection panel proceeded to invite, shortlist, and conduct conduct interviews for applicants for the positions of chairperson, secretary, and members of the Nyamira County Public Service Board in total defiance of clear judicial and senatorial pronouncements as per Annex 110-03, Annex CAN 11-04, Annex 15, Annex CAN 15/11A and B. These actions are contrary to constitutional principles and undermine public service integrity. Particular 1.6 on gross violation of the Constitution of Kenya 2010, County Governments Act 2012 by failing to appoint the chairperson, secretary, and members of the Nyamira County Public Service Board. Whereas Article 235 of the Constitution of Kenya 2010 provides that a county government is responsible for A, establishing and abolishing offices in its public service, B, appointing persons to hold or act in those offices and confirming appointments, and C, exercising disciplinary control over removing persons holding or acting in those offices. Whereas Section 58A(1) of the County Governments Act 2012 provides that whenever a vacancy arises in a county public service board, the governor shall nominate, and with the approval of the county assembly, appoint members to a selection panel for the purpose of selecting suitable candidates for appointment as members of the county public service board. And whereas Section 58A, Article 7, provides that the governor shall, within 7 days of receipt of the names forwarded under subsection 6, nominate one person, and at least 3, but not more than 5 others for appointment as chairperson and members of the county public service board, respectively, and forward the names to the county assembly for approval. The governor, His Excellency Amos Nyaribo, has to date failed to nominate for vetting, approval, and appointment of the chairperson, secretary, and members of the county public service board, despite vacancies arising in the Nyamira County Public Service Board as from 5th of July 2025. The absence of our county public service board has created a lacuna in the management of the human resource function of the county government of Nyamira. In the obtaining circumstances, the provisions of Article 235 of the Constitution of Kenya 2010 cannot be realized in the county Nyamira, in the Nyamira County Public Service. Additionally, these has eroded confidence and the public trust in the leadership of Governor Amos. Particular 1.7, Mr. Speaker, is on gross violation of the Constitution of Kenya 2010 and the County Governments Act 2012 by failing to submit annual reports and deliver annual state of county address to the county assembly for 2 consecutive years. Mr. Speaker, whereas Article 183(3) of the Constitution of Kenya 2010 provides that the County Executive Committee shall provide the County Assembly with full and regular reports on matters relating to the county, and Section 30, Article 2J and K of the County Governments Act 2012 mandates the governor to 1. J. Submit to the County Assembly an annual report on the implementation status of the county policies and plans. K. Deliver annual state of the county address containing such matters as may be specified in county legislation. The governor has failed to submit annual reports and deliver annual state of the county address to the county assembly of Nyamira for the past 2 consecutive years. That is 2023, 2024, 2024, 2025, as required by law. This failure constitutes a gross violation of constitutional and statutory provisions, demonstrating a blatant disregard for transparency, accountability, and oversight role of the county assembly. It further denies residents of Nyamira County an opportunity to hold their governor accountable. The governor's consistent and prolonged failure to deliver the constitutionally required state of the county address demonstrates a deliberate act to evade accountability to the county assembly and the people, thereby constituting a gross violation of constitutional and the statutory mandates. This is as per annexed CAN 17/12, which is willful disobedience of any judgment, decree, direction, order, or another process of a court, or will breach undertaking given to a court. Whereas the Employment and Labor Relations Court at Kisumu in ELRC JR number 10 of 2021 ordered the governor to appoint and pay salaries to Mr. Clive Owora. His Excellency Amos Nyaribo failed to appoint Mr. Clive Owora nominee for member of the county executive committee, despite the fact that nomination was cleared by law for appointment. The governor's disobedience of the High Court's order directing him to appoint Mr. Clive Owora resulted in the loss of a decree for a sum of 4,417,875. The actions of the governor, including delayed settlement, resulted into loss of public funds amounting to 6,922,203.75 million, being the decretal sum plus costs, interests, and other incidentals. This is as per annexed CAN 1.8/13A on that case of ELRCJR number 10 of 2021 at the Kisumu Employment and Labor Relations Court's judgment. Then there is another annexed CAN 1.8/13B, which is a consent dated 6th July 2023 and recorded in court on the 1st July 2023. Ground 2, Honorable Speaker, on abuse of office. Whereas Article 10 of the Constitution on National Values and Principles of Governance requires the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Article 73, 74, and 75 of the Constitution 2010 outline the responsibilities of state officers and the principles of public service, demanding objectivity, impartiality, and accountability, among others. Whereas Article 232(1) of the Constitution 2010 sets the values and principles of public service, requiring efficient use of resources, transparency, and fair competition and merit. Whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. His Excellency Amos Nyaribo abused his office in the management and administration of county affairs through the following acts as particularized below. Particular 2.1, Mr. Speaker. On abuse of office by improper use of his authority in procurement, in recruitment of staff without approved budget, which we call the recruitment frenzy, Mr. Speaker. Whereas Article 10 of the Constitution on National Values and Principles of Governance requires the observance of the rule of law, good governance, integrity, transparency, and accountability. Whereas Article 73, 74, 75 of the Constitution 2010 outlines the responsibilities of state officers and the principles of public service, demanding objectivity, impartiality, and accountability. Whereas Article 201A, D, and the E of the Constitution of Kenya 2010 state as follows: A, there shall be openness and accountability, including public participation in financial matters. B, public money shall be used in a prudent and responsible way. E, financial management shall be responsible and the fiscal reporting shall be clear. Whereas Article 232(1) of the Constitution 2010 states the values and principles of public service requiring efficient use of resources, transparency, and fair competition and merit. And whereas Section 107(2)(c) of the Public Finance Management Act 2012 requires that the county government is expended on wages and benefits for its public officers shall not exceed a percentage of the county government's total revenue as prescribed by the county executive member for finance in regulations and approved by the county assembly. Whereas Section 8(1)(c) of the County Governments Act 2012, which provides for the role of the county assembly, including approve the budget and expenditure of the county government in accordance with Article 207 of the Constitution, and the legislation contemplated in Article 222 of the Constitution, guided by Articles 201 and 203 of the Constitution. His Excellency the Governor presided over and influenced the approval of recruitment of staff without an approved budget as demonstrated in County Executive Committee minutes. That is minute number 04 02 2020 of 2021 of 26 February 2021 in his response to an inquiry from the Controller of Budget. This recruitment was approved by the County Executive with the full knowledge that there was no budget and provision. In the said response to issue number 4 in question, the Governor alleged that in lieu of a budget, the recruitment was based on the savings made from various separations, which included but not limited to retirement and resignations. Despite a resolution of the County Assembly to freeze new employment on account of lack of budgetary provision for any new recruitment dated 1st July 2021, which freezing was never vacated by a resolution of the County Assembly. Further, in spite of an advisory from the Secretary of the County Public Service Board dated 29 July 2021 to the County Executive to put the imbuing the recruitment in abeyance, considering that there is no budgetary provision for any recruitment. His Excellency Nyaribo has to date proceeded with a recruitment frenzy that has ballooned the county wage bill, making it unsustainable, irresponsible, and imprudent, contrary to the provisions of the Public Finance Management Act 2012. The Governor has influence on the recruitment of hundreds of staff without a budget, in defiance of ESCC, advisory and county assembly resolutions for political expedience and personal gain, constitutes a clear abuse of office aimed at fiscal plunder and a violation of constitutional values and principles of government. Since the year 2021, when His Excellency Nyaribo assumed office as a governor, he has influenced the recruitment of staff without budget and provision, and approval of the County Assembly of Nyamira, and particularly in February to April 2021, there was a recruitment of 49 officers. B, the recruitment of the Deputy County Secretary, County Attorney, support staff, ward and sub-county administrators. On March 9, 2023, the County Public Service Board advertised for 358 vacancies despite lack of approved budget for recruitment, a recruitment freeze by the County Assembly, and disregard for ESCC advisories. This recruitment projected to add Kenya shillings 325 million annually, proceeded without any budgetary allocation or approval. Outstanding arrears to the tune of 60 million arising from unpaid salaries to healthcare workers for a period of 7 months. This is as per MCA N21, stroke 14A and B, on Governor's response to control of budget dated 18th November 2021 and 3rd January 2024. At the same time, on MCA N 2.1 stroke 15A, which is an advisory letter from the Secretary, County Public Service Board on freezing recruitment due to lack of budget. MCA N 2.1 15B is a letter from the County Assembly communicating freeze of employment. There is also an MCA N21/16 on advertisement for 358 vacancies. There is also an Annex CAN 21/17 ABC on approved budget estimates 2021, 2022, 2022, 2023, and 2023, 2024 showing no allocation. Particular 2.2 is on abuse of office by influencing the appointment of Godfrey Kiriago and Imelda Nyaberi as Director of County Human Resource Management and Assistant Director of Human Resource Management, Payroll Manager, respectively. Whereas Article 179 of the Constitution designates the county governor as the chief executive of the county, whereas Article 232(1)G of the Constitution of Kenya 2010 mandates fair competition and merit as the basis for appointments and the right to equality and freedom from discrimination. Whereas Article 75, 76, 77 of the Constitution govern the conduct and financial probity of state officers. Whereas Section 30 of the County Government Act 2012 provides for the functions of the governor. Whereas Section 45 of the Anti-Corruption and Economic Crimes Act 2003 provides for protection of public property and revenue, whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. In a letter dated 18 January 2021, the County Secretary communicated the decision of the County Executive, an organ presided over by His Excellency Nyaribo, to the County Public Service Board seeking the secondment of two cherry-picked officers, Godfrey Kiriago and Imelda Nyaberi, to the positions of Director Human Resource and the Payroll Manager, respectively. In response, the chairperson of the County Public Service Board wrote back to the County Secretary demanding that the said officers ought to be vacant and that the process must follow the laid down procedures and the legal provisions. The governor influenced the transfer of substantive office holders to create room for the cherry-picked officers and cause irregular integration into the county payroll. By initiating the non-competitive appointment and the retention of the cherry-picked officers, the governor violated the principle of meritocracy and demonstrated a profound abuse of office, leading to a direct and a quantifiable loss of public funds, since the two offices were hitherto substantively occupied. The governor further influenced the appointment of Mr. Kiriago Godfrey to the position of Deputy County Secretary and influenced the renewal of Ms. Imelda Nyaberi's contract post her retirement age. This is as per Annex CA 12/18, a letter from the County Secretary to the Chairman, County Public Service Board, dated 18 January 2021, requesting for secondment of the two officers. Annex CAN 2.2/19, which is a response of the Chairman, County Public Service Board, dated 19 January 2021, advising that the secondment has to follow due process. Annex CAN 2.2/20 on appointment is an appointment letter for Kiriago. Annex 2.2/21A is an appointment letter for Imelda Nyaberi. Annex CAN 22/21A is on Kiriago. Annex 22/22 annex is an annex on appointment letter for Godfrey Kiriago as Deputy County Secretary. Annex CAN 2.2/23 is on a contract renewal letter for Mr. Imelda Nyaberi. Annex CAN 2.2/23B is a witness statement by one EMO. Particular 2.3, Honorable Speaker, is on abuse of office through personal enrichment for receipt of irregular salary arrears of Kenya shillings 5,649,706. Whereas Article 201A, D and E of the Constitution of Kenya state as follows: there shall be openness and accountability, including public participation in financial matters. F, public money shall be used in a prudent and responsible way. G, financial management shall be responsible and fiscal reporting shall be clear. Whereas Article 234A of the Constitution of Kenya 2010 mandates the Salaries and Remuneration Commission to set and regularly review the remuneration and the benefits of all state officers. Whereas Section 97 of the Public Finance Management Act 2012, that is the PMF Act, requires public funds to be used in accordance with the law and for the purpose for which they were appropriated. Whereas Section 46 of the Anti-Corruption and Economic Crimes Act of 2003 provides that a person who uses his office to improperly confer a benefit on himself or anyone else is guilty of an offense. Mr. Speaker, in September 2021, through the facilitation of the two JB officers, Mr. Godfrey Kriabo, Director Human Resource, and Imelda, the very payroll manager, the governor conferred upon himself an irregular salary payment christened as the arrears amounting to 5,649,706. It's apparent that there was no outstanding arrears due to the governor, since his assumption to office, and neither was he owed any arrears as deputy governor. The governor self-authorized the receipt of 5,649,706 in salary arrears outside of Salaries and Remuneration Commission guidelines is a clear act of personal enrichment, abuse of office, and a direct violation of the PFM Act. The governor has publicly confessed that he received the above irregular payment. The people of Nyamira lost services and development programs to the tune of 5.6 million on account of this office and all his actions. The governor has formed a habit of conferring upon himself irregular benefits going by other instances, for example, or for instance, in the year 2019, the governor caused to be paid a retrospective compensation of 13 million in allowances for housing, a benefit, not an allowance, and made a double medical claim in form of ex gratia, despite full settlement of his medical bills by the defunct NHIF or outside of SRC guidelines, which clearly demonstrate a pattern of personal enrichment through a pattern of personal enrichment, abuse of office, and a direct violation of PFM Act. The direct financial benefit to the governor constitutes a direct loss of public funds and demonstrates a clear case of personal enrichment through corrupt practices and abuse of office. This is clearly demonstrated in Annex CAN 2.3/24, which is an SRC circular gazette notice on governors deputy governors remuneration and benefits. There is also an Annex CAN 2.3/25, which is a circular on housing benefits for governors and deputy governors. There is also an Annex CAN 2.3/26A, which is a payslip for Kenya shillings 5,649,706, which was a payment made to His Excellency Amos. There is also an Annex 2.3/26B, a bundle of payslips for His Excellency from January to August 2021. There is also an Annex 2.3, Volume 2, a video clip of Governor confessing receipt of 5.6 million. Particular 2.4, Honorable Speaker, is abuse of office through systematic payroll fraud and a syndicate amounting to Kenya shillings 32 million, which is payroll haste. Besides an irregular receipt of 5,649,706 as already established in particular 2.3, the Governor presided over a well-orchestrated syndicate of payroll fraud which led to massive loss of public funds through huge, irregular, and unexplained salaries and special allowances paid to Ms. Rose Bosbori-Buto, an ECD teacher, who received 25,018,852. Ms. Gladys Moran, an ECD teacher, received 1,100,467. And Mr. Isaac Kirombo Njiri, an ECD teacher, who received 700,806 shillings. While under oath during his appearance before the Senate Public Accounts Committee, the Governor admitted to have received the illegal benefits. This can be demonstrated in Annex CAN 24/27 of January 2023 payslip for Isaac Kirombo Njiri. There is also Annex CAN 24/28 of a January 2023 payslip from Gladys Moran and Bane. Annex CAN 24/29 March 2023 payslip for Rose Bosbori-Buto. Honorable Speaker, particular 2.5 is on abuse of office by influencing dual appointments outside the lawful establishment. Whereas Article 235 of the Constitution of Kenya 2010 states that a county government is responsible within a framework of uniform norms and the standards prescribed by an act of parliament for A. Establishing and abolishing offices in its public service, B. Appointing persons to hold or act in those offices and confirming appointments, and C. Exercising disciplinary control over and removing persons holding or acting in those offices. Whereas Section 51 of the County Governments Act 2012 provides that there shall be established at the level of each sub-county the office of the sub-county administrator. And whereas Section 51(1) of the County Governments Act 2012 provides that there is established for each ward in a county the office of the ward administrator. Further, whereas these offices were already substantively filled in the year 2014, upon assumption of office in 2021, the Governor Amos Nyaribo, aware that these offices were substantively filled, deliberately allowed the recruitment of sub-county and ward administrators to fill the artificial, in quotes, vacancies leading to double appointments and hence double payment of salaries, depriving the county of development funds. Mr. Speaker, whereas Section 10(5) of the Employment Act 2007 provides for the procedure of a change of contract terms for an employee, the Governor, through letter reference NCG/CS/T-F/18, Volume 3/283, dated 27th June 2024, redeployed 10 officers who were awarded and sub-county administrators to positions in which they had no requisite competencies so as to create room for the dual appointments. This is demonstrated in Annex CAN 2.5/30, posting order from the county secretary deploying ward and sub-county administrators. Mr. Speaker, particular 2.6 is on abuse of office through usurpation of powers of the Auditor General and the County Public Service Board and violation of the process through illegal payroll audit and demotions. Mr. Speaker, Whereas Article 47 of the Constitution and the Fair Administrative Action Act 2015 enshrine the right to fair administrative action and due process, whereas Article 2294A(4) provides that within 6 months after the end of each financial year, the Auditor General shall audit and report in respect of that financial year the accounts of the national and county governments. So, Speaker, whereas Section 59A of the Constitution of the County Governments Act 2012 provides that the County Public Service Board shall A, be independent and shall not be subject to the direction or control of any other person or authority. And whereas Section 59F and Section 61G of the County Governments Act 2012 vest the powers to exercise disciplinary control over and to remove persons holding office in the County Public Service, squarely the County Public Service Board, whereas Section 35 of the Audit Act 2015 provides for the procedure and manner of auditing entities, or auditing public entities. In September 2021, the governor purported to demote more than 100 staff, which action was reversed by the Employment and Labor Relations Court sitting in Kisumu. Mr. Speaker, further in May and June 2024, he demoted another 254 staff on the basis of a failed audit report without due process, usurping the function that falls squarely under the purview of the County Public Service Board. The governor appointed a payroll audit team without due regard to Section 35 of the Audit Act, approval by the County Assembly or the Auditor General, contrary to legal requirements. Human resource payroll relates to public to use public funds and can only be audited as envisaged by Article 229 of the Constitution. The Auditor General is the only constitutionally mandated body to audit all state organs, including county governments, and it has not delegated enough have mandates to any institution to carry the Nyamira county payroll audit. The action of the government to carry county payroll audit without proper authorization or delegation is straight usurpation of the constitutional mandate of the Auditor General and therefore in violation of Article 229 of the Constitution of Kenya 2010. Article 2263 of the Constitution states that the accounts of all governments and state organs shall be audited by the Auditor General. The action of the governor to carry county payroll audit without proper authorization of the Office of the Auditor General is in contravention of the Constitution. Article 2291 of the Constitution creates the independent Office of the Auditor General, and Article 2294 of the Constitution cuts what the auditor ought to undertake. The action of the government to carry county payroll audit without proper authorization of the Office of the Auditor General and without the knowledge of the office undermines the independence of our constitutional office and is in contravention of the Constitution. Article 2295 of the Constitution states that the Auditor General has the liberty to audit and report on the accounts of any entity that is funded from public funds. Section 34 of the Public Audit Act 2015 provides for periodic audits to be undertaken by the Auditor General at his or her own initiative or upon request by an entity. The Auditor General has audited Nyamira County. There are audit reports and there is no explanation why the county government found existing audit reports inadequate. The governor has not requested the Auditor General to carry out any audit. The governor has not requested for the County Assembly of Nyamira to sanction the Auditor General to undertake any audit. Section 23 of the Public Audit Act 2015 provides for outsourcing of audit services, while Section 24 of the Public Audit Act 2015 provides for engagement of services of technical experts or consultants and professionals in fulfillment of Article 229(6) of the Constitution, which states the principal purpose of the audit is to confirm whether all non-public money has been applied lawfully and in an effective way. The Auditor General did not establish the firm that did the account payable audit. Audit is a process that follows cardinal guidelines, which the purported auditors of the county executive payroll did not follow before coming up with the purported payroll audit report. Section 31 of the Public Audit Act 2015 provides how the processes of audit shall be undertaken. Mr. Speaker, Section 36 of the Public Audit Act 2015 provides that the audit report is submitted to Parliament or County Assembly for tabling and debate. How the county payroll audit report, which was not done by or authorized by the Auditor General, will be placed to Parliament or the County Assembly for debate, and the consideration has not been explained. Section 37 of the Public Audit Act 2015 provides for forensic audit upon request by Parliament or county assemblies to establish fraud. The audit report is then placed to Parliament or the county assembly for debate and the consideration where appropriate resolutions and the actions to be taken emanate. The Governor therefore usurped the constitutional mandate of the Auditor General, which he arrogated himself to initiate payroll audit without authorization. The County Public Service Board in their submissions.
Subject terms of this. The public gallery is full, we will not tolerate any more ushering in of any visitor. It's full. So take the appropriate measures.
Honorable Speaker, the County Public Service Board in their submissions account appeals matter before the Public Service Commission through the respondent's reply to the appeal in paragraph 12, 13, and 20 affirmed that the Governor singularly commissioned the payroll audit, including appointment of an ad hoc committee that will digest the findings of the audit. The Public Service Board, in a communication dated 15 January 2025, reversed the Governor's purported demotions, explicitly implying that the demotions were processed without the body's involvement or approval, confirming the usurpation of the body's mandate. The County Executive Committee sitting in September 2025 resolved that it was aggrieved by the County Public Service Board's reversal and will be appealing against this decision, fully aware that it has no provision for appeal.
Honorable Chiles Matter,
Yes,
go straight to in conclusion. District.
Page 22, Honorable Speaker. Mr. Speaker, having gone through the voluminous accusations, Mr. Speaker, I wish to conclude on the foregoing grounds, particulars and evidence, which reveal a well-calculated, systematic and contemptuous pattern of constitutional sabotage and the fiscal plunder, Mr. Speaker. It is beyond doubt that His Excellency
Honourable members, minimize movements. This is a very sensitive matter. Kindly.
Mr. Speaker, it's beyond doubt that His Excellency Amos, Nyaribo, Governor of Nyamira County, has engaged in the gross violation of the Constitution and the other laws and abuse of office, Mr. Speaker. His actions, marked by illegal diversion of public resources and a blatant disregard for courts and this Assembly and the Senate, including the brass and usurpation of the County Public Service Board Authority, which the board itself was forced to reverse, have resulted in a demonstrable financial loss to the county government of Nyamira, amounting to approximately 54,567,000, with a further liability of 325 million annually due to unsustainable illegal hiring. I assert that, Mr. Speaker, this is not a matter of minor administrative error, but a sustained betrayal of the public trust demands the ultimate penalty. Nyaribo's continued tenure is a catastrophic risk to the future of Nyamira County and an affront to the principles of devolution. The people of Nyamira deserve a leadership that respects the rule of law and respects their public trust and confidence. There is a lot of impunity, Mr. Speaker. Now, therefore, Honorable Speaker, I move this county assembly, Mr. Speaker, and I beseech this county assembly, Mr. Speaker, to critically analyze the issue before them. Mr. Speaker, our county has been in the national limelight for the negative reasons, and this is one reason why this motion is before this House, Mr. Speaker. To save Nyamira, from the shame that we have undergone, Mr. Speaker, I move that, having considered the foregoing grounds and the overwhelming evidence in support thereof, resolve that we remove His Excellency Amos Nyaribo from the office of the Governor of Nyamira County by way of impeachment for gross violation of the Constitution and other laws and abuse of power. I beg to move, Mr. Speaker, and call upon the Honorable Juma Matunda to second. Thank you, Mr. Speaker.
The Honorable Juma Matunda.
Honorable Speaker, without blinking, I second the motion.
Honourable members, I now propose the question that this county assembly debates and approves the removal of Honourable His Excellency Amos Nyaribo, the Governor of Nyamira County, from office by way of impeachment on the following grounds: gross violation of the Constitution of Kenya and other laws. 2, abuse of office. Honourable members, the Constitution of Kenya Article 50, number 1 and 2, fair hearing. Every person has a right to have any dispute that can be resolved by the application of law decided in a fair and public hearing before a court or appropriate another independent and impartial tribunal or body. 2, every accused person has the right to a fair trial, which includes to be presumed innocent until contrary is proved. Go to G, 2G, to choose and be presented an advocate and to be informed of this right book tree. Together with our County Assembly standing orders, standing order number 65. Whenever the Constitution, any written rule of these standing orders requires the County Assembly to consider a petition or a proposal for removal of a person from office, the person shall be entitled to appear before the relevant committee of the County Assembly, considering the matter, and shall be entitled to a legal representation. B, requires the County Assembly to hear a person on grounds of removal from office, or in such a similar circumstances that County Assembly shall hear the person. Remembers, at this moment now, I will accord one, His Excellency Amos Nyaribo, the Governor of Nyamira, is hereby accorded a fair hearing. Sergeant at Arms. If the governor is in himself or is represented by an advocate, shall be accorded the chance, and the position is stand under address. Order. Office of the clerk, do the necessary. Be patient. Order. Order. Proceed. Office of the clerk, ensure that the mic is there. Proceed.
Honorable Speaker, my name is Lee, an advocate of the High Court, and I stand before you as counsel for the governor of Nyamira County, His Excellency Amos Nyaribo. Honorable Speaker, I shall be appearing alongside my colleague, Mr. Zelma Nuke. And we have counsel who will introduce himself immediately we are done with our responses. Thank you for giving us a chance to be heard, and it's a great honor and being an officer of the court, it gives us a lot of great pleasure hearing from the speaker say that this is a house of law and the law has to be followed. It is then our honest endeavor that we shall rely on nothing else, no hearsay, no innuendos, but the law. Honorable Speaker, we shall not engage in any sideshows. And with that, I would like to pave way for my colleague, Bonoke, who will handle ground 1, and then I shall come into ground 2 and conclusion of our responses.
Honorable Speaker, as my colleague has said, my name is Nyaribo, Counsel for the Governor, His Excellency Amos Nyaribo. I wish to echo his sentiments, but it's a pleasure that we are here, and it is also important to acknowledge that the rule of law should not be said or being said, but at least should be seen to be done. So I stand here pursuant to the provision of the Constitution, that is Article 50, the right to fair hearing, and we shall be presenting the response of His Excellency the Governor to the impeachment motion. Honorable Speaker, the doctrine of separation of powers stands at the heart of the constitutional democracy, ensuring that no single arm of government, be it the executive, legislature, and the judiciary, wields unchecked authority. Honorable Speaker, rooted in the classical political philosophy of Montesquieu, the principle divides the government in the 3 arms that are listed above. Mr. Speaker, sir, the mandate and mechanism of accountability is enshrined in the Constitution of Kenya 2010, and not only adopts but firmly entrenched this doctrine in the foundational pillars of governance. Under the Constitution, Parliament, and indeed this House, is vested with authority to enact laws, provide oversight over the President, and now, as a county assembly, over the county governor. Mr. Speaker, sir, the House is charged with the responsibility of implementing the laws running the affairs of the county government. The judiciary, being an independent arm, is insulated from political influence, interprets the law, and safeguards constitutionalism through judicial review. The structural arrangements in reinforcing the robust checks and balances, as we have outlined before, ensures that each branch puts corporations within themselves, so that at least, as I said, the laws or the law or the rule of law can be seen to be done. As I wind up these opening remarks, Mr. Speaker, sir, the wisdom behind the Kenyan Constitution, designs a government that separates balances power, is better positioned to prevent abuse, protect rights, promote transparency and accountability of leadership. Through this doctrine, the Constitution advances a democratic government to secure the rule of law, principles that remain essential to Kenyan political stability and the protection of the citizens' freedom. And it does not exclude the citizens of Nyamira, of the great Nyamira County. Mr. Speaker, sir, we have gone through the motion and we shall respond sequentially as follows. In response to ground 1.1, the particulars I've read, gross violation of the Constitution of Kenya 2010, the County Government Act 24, through deliberate formal engagement and endorsement, and support of unlawful, illegal, and unconstitutional bunge mashinani. Honorable Speaker, honorable members, and the public, bunge mashinani is not a strange word to this house as we speak. This is a fact, and it has been litigated, which I personally had the privilege of appearing in those matters, as many of the members in the house may know. Prior to the suspension of the Honorable Okero, the former Speaker of this House, in October 2024, I believe, and the public will bear me witness, that the Assembly had no run laws before, such that upon the suspension, which was challenged in court, petition number 8 of 2024, Nyamira, Enoch Okero versus the Speaker and the County Assembly of Nyamira. There were orders that were issued, and it cannot be gainsaid since this is something that has been spoken over the time. Upon the court issuing orders of the discharge and powers of the then Speaker, it will be noted that the Honorable Governor, His Excellency Nyaribo, does not have express powers to interfere with the mandate of the Constitution, or rather of the Assembly, as spelled out. Pursuant to the doctrine of the rule of law and the principles of good governance, the County Executive, which is headed by His Excellency the Governor, and the County Assembly is obligated at all times in its decision working pursue legality, both procedural and substantive, following statute enacted and complying with court orders. And that is where I draw the line. Court orders, judicial decree, as and when they are issued. Mr. Speaker, sir, the Article 175, which forms part of my introduction and my opening statement, provides for the doctrine of separation of powers. It is important that we note that upon promulgation of this new constitution, it created the arms of government. The ground in which we put these sentiments is that the Speaker, the Governor does not have express control of the House. Mr. Speaker, sir, the County Executive, therefore, in law, bears no direct causative or contributory capability in as far as infighting within the County Assembly. Article 176(1) of the Constitution explicit and the expression that there can only be one County Assembly in every county government. And this is very much aware. This is a statement that our client, His Excellency the Governor, is very much aware. So that at no given point, there can be two county assemblies operating. Allow me to mention, or rather go to the details of the case that I've highlighted before. That's Constitutional Petition number 8 of 2024. And I know for sure the House is very much aware. But allow me to state this to the public, which might not be aware.
Order. Address the Speaker. You are stating to the House,
Very well,
to the
Speaker.
public,
I am guided.
and I humbly request that you reply as per the response received in the Speaker's office. And the matters that are up the matters that are active in the Labor and Relations Court Kisumu should not be part of the issues that are being handled today. Proceed.
Mr. Speaker, I am well guided. I will address to you. And I will beg your indulgence, Mr. Speaker, on the issue of the court orders and the decrees and proceedings in court. Mr. Speaker, it is a matter of public notoriety that there are cases in court. And if the governor feels that these cases directly affect his response, Mr. Speaker, sir, I beg to move that the law permits me to refer to those orders, decrees, and proceedings. Mr. Speaker, sir, I will be guided on that aspect. Petition number 8 of 2024 is a concluded petition. It is not a matter that is pending before the courts. And it was transferred to Kisumu, PLRC petition number 52 of 2024, Mr. Speaker, sir. The petition has been concluded. So therefore, I will properly refer to that. In the court's ruling of the 4th of November 2024, in the Nyamira petition, Enoch Ogero versus the County Assembly of Nyamira and others, in that ruling, Mr. Speaker, sir, at paragraph 34, the court went ahead to state that I find the act of removing the speaker from office as a speaker of the county assembly, whether through suspension, impeachment, with the full knowledge of the existence of conservatory orders, amounted to interference with the discharge of his duties as a speaker. I therefore find that the respondents are guilty blatant disobedience of the state court orders, a conduct which this court cannot countenance. As at the time when the former speaker of this house was gazetting Bunge Mashinani, there were existing court orders which I have referred to, Honorable Speaker. And showing the governor is a law-abiding citizen and as head of the executive had to oblige to those court orders, Your Lordship, Mr. Speaker, sir. May it be on record that the County Assembly, this house, being aggrieved by the State Gazette notice, gazetting Bunge Mashinani, which is Gazette Notice 14229 of 2024, moved to the court. So it is evident that there was an issue. The Assembly was not amused by the existence of Bunge Mashinani, and that is why it had to move the court. I will shortly tell you what the court decided. But before we go to what the court decided, Mr. Speaker, sir, allow me to also refer to this very case, that is petition number 7 of Judicial Review number 7 of 2024. This is a court record, and I know for sure that the House is very much aware. In this Judicial Review, Mr. Speaker, sir, having been aggrieved, the County Assembly moved to challenge those Gazette notices that had been gazetted by the former Speaker. What in essence that tells us is that the Gazette notices existed as at that time when the County Assembly was moving to court. And in a ruling dated 30th of January, the court observed as follows. It is not in dispute that on the 11th of October, this court issued conservatory orders directing parties to maintain status quo, pending the hearing and determination of the application filed in the first petition that I mentioned, petition number 8 of 2024, where the exported applicant, the former Speaker, Enoch Ogero, was a party. The judge further went ahead to say, to my mind, the effect of the said orders was to stop subsequent actions against the holder of the office of the Speaker of the County Assembly, including removing from office by way of impeachment. Mr. Speaker, I will not delve into the issue of impeachment, but allow me to speak on behalf of the government. What then makes What then will the governor make of all these judicial pronouncements? And as I've highlighted, the doctrine of separation of power gives the Honorable Governor the mandate to confine himself to judicial authorities, to court orders, and any other judicial pronouncement that may come. It will be noted, Mr. Speaker, sir, that there was another petition filed, which in essence stopped the Speaker from acting as at the time. Mr. Speaker, sir, at this time, it is important to note that no court has set aside the Bunge Mashinani, and that is why there was splitting between the members of the County Assembly and the other faction.
Order, honourable members. Order. Order.
Mr. Speaker, sir, I'm referring to gazette notices, I'm referring to court orders, which we have annexed in our responses. This is not hearsay, this is what is on record. And it is important that we lay out the facts as they are.
Order. Order, honourable members. Order. You have up to 12:10 to conclude the submissions. Thank you. Because of the timeline and guidelines of the standing orders.
Mr. Speaker, there is an averment in our response that the Honorable Governor only dealt with these issues of the gazette notices that were leveled. Mr. Speaker, sir, as I will be showing throughout my submissions, there is the element of the Bomet judgment, and I must bring it to the attention of the Speaker, because it forms part of our responses in ground number 1. In the Bomet judgment, Mr. Speaker, sir, this judgment is read and delivered on the 4th of June, 2024. And as at the time, the judgment did declare all the proceedings of the gazetted, it quashed the gazette notices and declared the proceedings. To our mind, and to the court's mind, it meant that between the day when there were conservatory orders, there could be a possibility that the exercise of the office of the Speaker was intact, and the orders, the gazette notices were valid up until that time, Your Honor, Mr. Speaker. Allow me to refer to Petition 1 of 2024, Enoch Okero Gori and 12 others, versus the County Assembly of Nyamira. This is a petition that had sought to reverse the impeachment. Because we refer to this, Mr. Speaker, sir, because in most of the grounds that have been highlighted in ground number 1 to number 7 to ground number 8, Mr. Speaker, sir, all these grounds are attributed to the actions said to be done by the governor during the period in which the County Assembly had got their own ranks in between. Mr. Speaker, may it be on record that as of today, we have a consent and an order of the court that sets aside the impeachment of Honorable Okero. What then that means, Mr. Speaker, sir, I have referred to ground in our next 1B, which is the specific order under the consent, Mr. Speaker, sir, which sets aside the entire impeachment proceedings.
Order. I told you any matter that is active in court should not be part of the subject. Kindly, Wakili, we are aware of the consent, and the consent is being challenged in Kisumu. It's not in force. There is an order that is putting aside the consent.
Mr. Speaker, allow me, there is an order that adopted the concept. And if there is an order staying the execution, it is the execution of the monies that were to be paid to the honorable Okelo. And it's important that the House knows of this. We have an order.
Order. You could have served, is the order part of this?
It is served,
Which?
Mr. Speaker, sir.
We will not wait you to mislead the House. Actually, you are out of order. Assume your seat. You are out of order. Assume your seat. We will not wait that you mislead the House. Assume your seat. Assume your seat. Lead counsel, you take over. You have 20 minutes. Lead counsel, kindly restrain yourself to the response that the office of the speaker received and proceed.
Mr. Speaker. Honorable Speaker, sir. May it just be brought to your attention that
Order. Honorable Nyamira, resume your seat. Restrain your movements, honorable members. We need to ensure minimum movements in the House. Order. Proceed.
may it be brought to your attention that as council, we have the privilege of understanding and putting out what we read in the law. Once we take your position to stand down or have my colleague as being out of order, I reiterate your statement at the beginning, where you indicated that this is indeed a house of laws. You have every machinery to counter-check the truths or half-truths that then would have been said in these debates. But that notwithstanding, the issue relating to the orders issued and as attached cannot then be thrown to the wind. These are standing orders and they are binding. Not only to us, but to everybody who is mentioned in that particular case. We cannot assume or pretend that they're not binding. They are binding. Mr. Speaker, I will proceed to the allegation to save on the time of this Honorable Assembly, I'd like to point out that grounds 1 to ground 7 to ground 6, Mr. Speaker, sir, relate to the actions of His Excellency the Governor following to the letter to the separation of powers between the executive and the legislature. He got communication from the speaker sitting then. It's not for the government to come and check on what has been discussed in the House. The governor receives directions through the clerk, not even through the speaker, through the clerk, of what has been held and deliberated in this house. The governor was served with gazette notices, which are binding. And the mover of the motion has pointed out that the governor was not following the law. But the governor is just served with gazette notices, which are binding, which in essence are the law. How then can he be accused of following one gazette notice and not following the other? We cannot cherry pick, as the mover of the motion said, on what to follow, not to follow. It's not on us. We do not have the standing whatsoever to choose on what to follow and what not to follow. The governor does not have, the speaker doesn't have, and neither does any member of the assembly.
Bill Council, are you aware that the same governor resubmitted the budget that was handled in the said with this house?
Ayona, I will come to that.
Thank you. Proceed.
Just allow me to ventilate on my issues, and then you can point out what you find not in alignment. So then, how then can we come to these honorable hours? How can the mover then stand and say that the governor is in violation of the law, when indeed, up to the point that he followed these deliberations from Bunge Mashinani, they stood as the law up until the Omer case was up and it has been. How then is it the governor's undoing? The issue of Bunge Mashinani can be ventilated in this house till the end of the day, and I know because of the differences, Mr. Speaker, sir, that we have in the house, I doubt that ever we'll come up with a conscious position. Mr. Speaker, there is a letter dated 12 June 2025. I'm responding to particular number 1.6, the failure to appoint the chairperson. There's a letter dated 12th of June 2025. From the County Assembly. On the interviews of the members of the Public Service Board, and the County Assembly stops the governor. Sorry, stops the county secretary from proceeding with the interviews of the members of the County Public Service Board. This same assembly that is accusing the governor of not appointing a County Public Service Board sent communication to the county secretary stopping it. Then to the move of the motion, we wonder, is it that you are not in the assembly? Is it that you are not alive to the proceedings of this letter dated the 12th of June 2025? Or is it a case of shooting in the dark and hoping to reach a target? On particular 1.7, the gross violation of the Constitution by failing to submit annual reports and deliver annual state of the county addresses. It will be noted that that's found in page 11 of our response. It will be noted that reports have always been submitted County Assembly. And we have annexed them in our response to the County Annual Reports June 2023-2024 submitted to the Assembly on the 25th of January 2024. The County Annual Reports June 2024-2025 was submitted to the Assembly and received on the 31st of July. The Budget Implementation Report fourth quarter 2023-2024 was submitted to the Assembly and received on the 30th July 2024. The list goes on and on. Mr. Speaker, we wonder once again, did this escape the move of the motion? Or once again, is it just throwing punches, hoping to hit the target? What we find very peculiar and very interesting, Mr. Speaker, is ground number 1.8, where the mover says the county lost a lot of money. In his words, colossal amounts of money because of the delay or refusal or the failure, in his words, failure to appoint and obey court orders. What the mover fails to understand is that in that same court order and ruling in Kisumu ELRC number 10 of 2021, his house, the county assembly, is faulted by the judge for failing to carry out its duties in the appointment of Clyde Owola. But what has the mover done? In total disregard of separation of powers, he's lumped it on the government. Mr. Speaker, I will point you to page 177 of our response, where the court states, you'll bear with me, I will read it. The third respondent, Mr. Speaker, the third respondent here being the county assembly. Averments were clear that once the nominees and the public were notified of their approval hearings, nothing happened in relation to the applicant's approval for appointment or rejection. Nothing happened from this house. It's simply his house, did not address the court on what transpired after the hearings. The third respondent only said that her committee facilitated public participation and openness. I'll go to the end. No mention of the result of the vetting process. The vetting is done in this house. There is no mention of the result from this house. But what has the mover done? Lump it at the doorstep of the government. He talked about loss of funds. So, Speaker, I'll point you to page 178. Paragraph 35(4) of the judgment. It reads that the cost of the proceedings be borne by the third respondent.
Yes, Honorable Legal Majority.
Thank you, Honourable Speaker. I wish to move for a motion for this House to extend its sitting hours or sitting time. Pursuant to Standing Order 29, subsection 1, subsection 2, 3A, so as to allow the House, Honourable Speaker, to deliberate on the motion that is on the floor. I beg to move and call upon the Majority Whip, Honourable Duke Nyaribo, to second.
Honorable Duke Nyaribo, Majority Whip.
Mr. Speaker, without much ado, I want to second because of the importance.
I don't know if the generosity from the Legal majority meant that you're giving us more time. No, Mr. Speaker, I'm addressing the Speaker.
Proceed. The time was requested for the House to extend its time from 12:30 to the time that we can finish the issues. Proceed. You still have 10 minutes.
I may have misread the intentions on the leader majority. I thought he was being generous for the first time to us, but it's still the narrative. So, to the move of the motion, I was pointing out that the court did, in paragraph 35(4) of its judgment, find this house culpable and ask the court, this house to pay costs. Again, Mr. Speaker, sir, the losses that were incurred in this particular case resulted from, did not come at the point of judgment. These losses incurred came way after the order on costs was not honored by this particular house. What have we done? Lumped it on the doorstep of the government. My Lord, something else, Mr. Speaker, something else that we ought to not, we would, as a person, I would be very concerned on cases of misappropriation of funds. And the House has been told that there was an improper, referring to 2.1, there was an improper use of authority, of the Speaker's authority, the government authority in recruitment of the staff without approved budgets. Mr. Speaker, on page 13 of our responses, we've labored to show the exits, number of officers who exited service to this county, and the wage bill saved therein. And it goes a long way to show that indeed the governor did not disregard the freeze on employment. And in any case, the motion, in particular 2.1 of this motion, the advisory was issued after the recruitment. That advisory cannot be applied retrospectively. What would happen if that advice is applied retrospectively? That means that this county then would incur losses from numerous litigation cases because these people have been handed their letter of employment. It's been shown that there was indeed gaps. And these, Mr. Speaker, would also address the purported issue of dual appointments and creation of artificial vacancies. We presented concrete evidence. This House in the motion was not presented even with an iota of evidence. Just hearsay. Where it comes from, they will call it stories ajaba. Nothing was presented to show that indeed there was any dual appointment. And in any case, I'm sure this House has many right members. I've seen my senior here. How then would it miss? How then would it miss the House that the role of appointments is not under the purview of the government? This was right under the County Public Service Board. Has anybody in the County Public Service Board been called here or been mentioned with this motion? None whatsoever. A classic case of witch hunt. The purported freeze is addressed to the CEO of the County Public Service Board and copied to the Speaker of this House. Nowhere is the governor mentioned. On the recruitment of the Deputy County Secretary, the County Attorney, and support staff, and quite a number of people, the appointments were done by the County Public Service Board, which is an independent body. My senior would bear me witness, Mr. Honorable Juma. Well, if you decide to abandon the law today, but this is clear in the law, Section 59A of the CGA Act. These appointments.
Kindly address the chair. Address the chair.
My Lord, in our training, we always asked to respect our seniors. You bear me witness, but I stand guided. But what has been done by in this motion, the employment of these officers, where there's a body mandated by law to perform such functions, has been lumped on the doorstep of the government. Mr. Speaker, these and 2.2 and 2.5 are clear allegations which do not at all touch on the office of the government. Our response to 2.6, Mr. Speaker, I pray that you add me 5 minutes when the Honorable Leader of Majority decided to give me more time, but I think when you came in, we'd already gone beyond it. Just give me 5 minutes, it took my time. Thank you very much. So, my Lord, that, Mr. Speaker, so that addresses 2.2, 2.4, 2.5, 2.6. I wish the House or members of the County Attorney would never seen the letter and under the address of the governor. The governor said, I've not stopped this particular officer from working. So, how then does a matter that has been concluded by court and found to not touch on the governor later on come before this assembly as an undoing or the undoing of the government? I wish we had more time. There is an issue we would have addressed that I would like to echo. Unfortunately, Mr. Speaker saw the mover is, I thought he was sleeping. And unfortunately, there are things I agree with him. The move of the motion says the people of Nyamira deserve a leader that respects the law. That is the current government. He's not been tried or found wanting. But again, as we started, we said this is a house of law. It's not a house of feelings. If everybody was to apply their feelings, maybe I'd have the highest feelings. Maybe the chief would have his highest feelings here. But these are house of the law. We are constrained under the law. From the foregoing, the governor has been able to demonstrate from all grounds set in this motion to seek to impeach him that they lack legal basis and acumen as enshrined under Article 18(1) of the Constitution of Kenya. The governor has demonstrated, not in detail as we would have, but we've submitted the document which is in detail, that he neither in any way grossly violated the Constitution nor abused the office.
Thank you.
I'm
Thank you.
finishing. It's my last paragraph, Mr. Speaker.
Thank you.
Can I finish?
Yeah.
Finish. If I may bring it to the attention of the House, which is common knowledge, this is the third time an impeachment motion is being moved against the governor. That notwithstanding, it's just a corner on the road, not the end of the road. The governor has diligently discharged his duties to the great county of Nyamira. He served his constituents selflessly. There is no constituent of Nyamira who's ever who's ever moved to impeach the governor, save for one who's vested with office. The governor has worked selflessly to ensure that the constituents of Nyamira fully enjoy the fruits of the volation. Mr. Speaker, the definition of gross violation laid out in paragraph 233(2), it says it's not every violation or breach of the Constitution that is or can lead to the removal of a government. Not every. When you look at this, it's under those not every. They cannot lead to the removal of the government. That's its humble appeal to the House, Mr. Speaker. And we appeal to the honorable members, who we truly respect, that we ought to work in concert, to discharge our mandate.
Members, order. Honorable Duke Masira, order. Order. Honorable Ken Atuti, order. Decorum,
It's
order.
our humble appeal to the honorable members that we ought to work in concert. We, here refers to His Excellency the Governor and yourselves, to discharge the mandate as the elected leaders of Nyamira County.
Thank you, Senior Counsel, the Council, Lead Council, for His Excellency Amos Kimumi Nyaribo, the Governor of Nyamira County. Now, as guided by the law, honorable members, now we can proceed with the debate. Counsels for the accused, now you can't be excused as for the governor, you can be excused. If you also wish to take a leave, you can leave. But if you wish to remain, you can remain as we dictate. Proceed. Honourable members, the floor is open for debate, and the council for the governor has a right to reply thereafter the debate. We'll give them 10 minutes to 15 to reply. The Honourable Kenya Tuti Nyamira.
Thank you, Honorable Speaker. Honorable Speaker, here comes our time with my public interests overrides the personal interest. Honorable Speaker, sir, first and foremost, as the minority chief whip, I know the Honorable Speaker, the move of the motion comes from the minority wing. Us as a minority wing, out of 11 members, 9 members signed for this motion. We brought in this Honorable House, Mr. Speaker, here. And it was indeed through consultation, the mover, who is the chair of implementation, in conjunction with the Committee of Finance, chaired by Honorable Chuma, the Committee of Budget, chaired by Honorable Masira, and the Committee of Public Investment and the Accounts Committee, chaired by myself, that we took all data, we took all the information, we analyzed, and we came up with this. Honorable Speaker, sir, I know I've been in Senate with His Excellency the Governor in several occasions. But today, as we stand here, I know there are provisions there is a collision to bring the justice at the expense of the interests of Nyamirans through bribery and other means of the speaker. And I know at one time, the Honorable Desmond Tutu,
Honorable Nyamira, the allegation you have raised is so serious. If you cannot substantiate, you withdraw and apologize. Do you have the evidence over the same?
Honorable Speaker.
If you don't, kindly withdraw and apologize.
Thank you. I withdraw, Honorable Speaker. But I say proceed. I want to say.
Withdraw and apologize.
Honorable Speaker, I apologize.
Order.
Other members in the House speaks loud.
Order. Honorable Nyamira, if you are not order, resume your seat. Resume your
I
seat.
withdraw and apologize, Honorable Speaker. I can proceed. I'm sorry.
Resume your seat. Honorable Leader of Majority, resume your seat. Honorable members, we have to debate as guided by our standing orders and as guided by the law of the land. If you have no evidence over an allegation that you pronounce here, where you don't do it. Honorable Nyamira, for the last time, you stand, you withdraw and apologize. But if you have the evidence, you table the evidence for further processing. Proceed.
Thank you, Honorable Speaker. Thank you. I withdraw and apologize, Honorable Speaker.
Thank you. Proceed.
Thank you, Honorable
To
Speaker.
1 minute.
Thank you, Honorable Speaker. In response, I wanted also to go to the response. Then I want to make the information. It happened I served in the first session of this House in 2017. In that time, in 2016, Honorable Speaker, we gazetted the Bunge Mashinani. And since then, there is no any other Bunge Mashinani was gazetted up to current. Honorable, there are procedures that allow members to go to Bunge Mashinani. So I want to inform the legal counsel that whatever, if you check on the evidence that is being attached, the Gazette notes they are using was for Kiabu and was forgery. Finally, Honorable Speaker, sir, on the pay slips issues on budgeting. Honorable Speaker, His Excellency team has replied through the council, legal counsel, that there was money saved. According to public, the TMF Act, any money that is saved, it's called as revenue. It has to come to the kitty, reallocated, and then the county assembly approves it. Minus all of that, that was a shortcut, and it is legal. Thank you, Mr. Speaker. I support.
The Honorable Amos Matunda.
Honorable Speaker, thank you for allowing me to put my input in this. And I'd like to congratulate my counsel, my friend, Ugui, for his eloquent response. But Mr. Speaker, when I was looking at him on his face, I realized that he was actually straining to give a response. However,
Order. Honorable member.
Mr.
How did you realize that?
I'm very keen.
Thank you. Proceed.
Mr. Speaker, Mr. Ompui took us through all the allegations up to 2.7. But technically, he jumped. Particular 2 is skipped 2.3 up to his office through personal enrichment from receipt of irregular salary arrears of 5.6 or 5.6 million. Mr. Speaker, I have gone through the annexure, a letter from EACC, which is annexure 11A, And I want to take you to that. I'll take very few minutes, Mr. Speaker. This is a letter which was written by EACC officer, dated 17th of October 2022, addressed to His Excellency the Government. Mr. Speaker, that letter is very, 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 very succinct in your ways. And the EACC was informing the Governor that the preliminary findings arising from the ongoing investigation indicate that during the period from March 2013 to December 2020 and January to September 2021, when he served as a deputy governor and the governor of Nyamira respectively, he regularly received wrongful salary and later salary arrears whose gross total was over 5.6 million. Mr. Speaker, that letter goes down to look at it. It says, in order, this is a request from the governor, that in order to refer, he was given a condition, in order to refund the money, then he said, the letter says, in order to refund the same amount as requested by your letter dated under reference, kindly make cash deposit or transfer to the Commission's asset recovery account whose details are given below. The governor was given an account to refund that money because the preliminary findings were that he was guilty of the offense. Later, that letter, Mr. Speaker, I'm sorry, it was received by the governor on 18th October 2022 and they stamped. You go further, that is Annexed 11C, 11E. That is a letter from His Excellency the Governor to EACC. It is dated 22nd March 2024. It is inquiring on status of investigations. Status of investigations. If you go through that letter, it says your letter reference EACC this dated 17th October and the minutes of the deliberation of the ad hoc ADR alternative dispute resolution committee on dated 2nd June 2023 refers. Further to my letter reference number this dated 7th November 2022 confirming refund payment of Kenya shillings, all these and this and this, and we further direct you deposit 40,000 the Commission's account number this at KCB Bank Money. This in effect clears the computed outstanding overpayment. This is the governor writing to USCC that I have refunded the outstanding amount which I was paid, and I am now cognizant of the contents of the letter dated above. And then he concludes, the purpose of this letter is to request the Commission to confirm compliance with the agreed resolution of the ADR and the further request for a clearance letter. If you look at the reference of that letter, is inquiry of the status. But he's asking, down there, the conclusion is, I am requesting for a clearance letter. What does it mean? The governor received the arrest, he received the wrongful salary that is talked about, and the money which was meant for Nyamira people has already been recovered by EACC. Remember, money is not a liability but an asset. Mr. Speaker, that I don't know. Mr. Obi will be given time to respond.
Order. Address the chair. Honorable address the chair.
That's why, Speaker, I'm facing you.
Thank you.
And I would require that he be given time because he has skipped the ground so that we can get the correct information. You have now known that even the resolution of the alternative dispute has not been attached in this response. I rest my submissions and the governor is guilty of this crime.
Thank you. The Honorable Thomas Vincent Kalecha, member for Kebonyo.
The great Kenya Ward is hereby represented by myself, Honorable Vincent Nyamira. Thank you, Mr. Speaker. I want to point out one or two. The councils for the House here, Rwanda Latemo and the Bonuke, are in record having presented the criminals at the Bunge Mashinani. And therefore, what they came here to do is to protect their interests during Bunge Mashinani.
Order. Order.
Honorable Speaker.
Order. Receive your seat. Withdraw the statement and apologies to the senior council representing His Excellency the Governor, Honorable Amos Nyaribo.
Honorable Speaker, I withdraw and apologize that they were representing criminals, but in they were representing
Order. Withdraw without an explanation.
I withdraw and apologize.
Thank you. Proceed.
As they were representing the governor, they dwelled more on Bunge Mashinani. Therefore, and I want to say that the illegality conducted by governor was their advice because they were there in Bunge Mashinani, Honorable Speaker. Two, in their submission, we learned that they also knew that the governor submitted the budgets, they submitted the budget to the assembly. They also submitted the names. Dr. Beris, governor also submitted the CFSP. Honorable Speaker, the governor also submitted municipality board names. What does this one tell us? He accepted that what he had done earlier was illegal, so he wants to correct an illegality by submitting. If it wasn't illegal, then he could have not submitted. Honorable Speaker, let us not be misled and be given the wrong information. The interviews that was taught in a letter was not because we did not want the board chair. This was because the panel was wrongly constituted and it was illegally in office. The panel that were interviewing the names. So I didn't feel that the panel was correct, then we could have not written a letter from here to stop the interview. So we cannot be cheated and given wrong information that the assembly denied the putting in place of the chair and the board. Finally, Honorable Speaker, I fail to know how the senior legal councils don't understand that a payslip is a confidential document of the owner. We have said they were paid. It is them to prove that they were not paid by submitting the correct payslip if there is. A payslip cannot be put in public because it's a confidential document of the owner. Let them prove here by bringing otherwise. Finally, Honorable Speaker, the senior council is humorous by telling us that we have tried to meet the governor 3 times. Just a simple question. Is there a ceiling for how many times we should try to engage the governor? We can do it several times. It is underperforming. Thank you, Mr. Speaker.
The Honorable Minda Rich, member for Magomba Ward.
Thank you, Mr. Speaker, for the 2 minutes. Mr. Speaker, I've keenly listened to the response made by the governor, as presented by the council. Mr. Speaker, one item has escaped the attention of the Speaker in response of the governor in response to the petition presented. One, the appointment of Dr. Paris Namoke Oroko as CC member in the council government. The Speaker, the Constitution demands that such a nominee must be presented to the Assembly for approval or disapproval. The Speaker, the same was not done, despite the 6 members been in office for about a year now. I also listened to the presentation by my colleagues in relation to the final orders given by the community court, which nullified all activities that were carried out at the purported Bunge Mashinani, and which activity, one of the activities was the issue of Dr. Perry's revocation. Mr. Speaker, I have not had any satisfactory response from the governor relating on this matter, and it's a weighty matter. The C6 member continues to draw salaries and allowances from the county of Nyamira illegally, and even on that ground alone, the failure of the governor to submit or to bring the name to the County Assembly for approval is sufficient to warrant impeachment. There are other issues I have, but if you give me 2 minutes, Mr. Speaker, let me raise my case. Thank you.
Thank you, the Honorable Duke Masira. 1 minute.
Mr. Speaker, I may not even take a minute. It's just an observation, Mr. Speaker. If for sure and indeed the Bunge Mashinani was legit, why did the governor resubmit the name of Dr. Perez Nyabuke Oroko back to the legit county assembly, Mr. Speaker? And Mr. Speaker, the second observation, Mr. Speaker, when I heard the council telling us that the assembly did not, and that the assembly in the case of Craig Ogwaro was not party to the case, Mr. Speaker. So I really want to ask the council to give the public the legal mind which cannot shed some light to public to also understand that whatever that he has been telling us is also null and void if I was given a chance to be a judge today here, Mr. Speaker.
1 minute, the Honorable Josiah Mangera, voice is away.
Thank you, Mr. Speaker. Mr. Speaker, I really do not want to take a lot of time, but just wanted to remind the councils just one simple item, that they are representing the CEO of the county, whose name is His Excellency. His Excellency. When we are talking about the word His Excellency, in fact, Honorable Speaker, it means that he should be beyond suspicion. Sisters was beyond suspicion. He should be just like Sister's wife. That's why we are saying, when you are a CEO or a county, a CEO of a country, there is something called taking responsibility. Taking responsibility. That, because I had the councils saying that the people who should be called here are the CEC, the board members, and so on. But who is the CEO of this county? It must take responsibility. Thank you, Honorable Speaker.
Thank you. Honorable members, I now give the council for the governor to reply, and then the move of the motion, and then we move to another stage. Five minutes to reply.
Thank you, Mr. Honorable Speaker. I did say 15, but I realized maybe you're just being economical in time. I will try and finish it, say 15 earlier on, we've gone down to 5. But I will follow the last one, because legally you follow the last order. In response to the Chief Whip, Majority Whip, the case involving Clive Ogwara is Clive Lai Nyada Obora, the applicant, versus the governor of Nyamira County, the county government of Nyamira County, the county assembly of Nyamira County. You are a party. One Honorable Manager, if I'm not wrong, spoke about the confidentiality of a case.
What is it, the Honorable Deputy Speaker?
Thank you, Honorable Speaker. The County Assembly was party, and I want to inform the Council that in law, or in our standing orders and the County Government Acts, if the Governor sends a name to this Honorable House and the 14 days expires, then he did assume that the name was part. So the idea of telling us that the Assembly did not approve the name of Clever Water, then the Governor was ignorant of the law.
Okay.
That's the information.
I wish you give the council time to reply. Proceed. Yes, sir.
Just a quick rejoinder to what has been said by the Deputy Speaker. The court found the county assembly. I did not find the county assembly. The court. This is binding. You cannot have any other opinion on it. It's closed. On the issue of the payslips, we've been told there are confidential documents which have been submitted by the member. There is no waiver on confidentiality by the owners of these payslips attached to this motion. That then, ideally, we cannot discuss about it in light of the Data Protection Act. Whatever we'll do about these payslips is illegal affidavit. There is no affidavit by the owners of those payslips that have been rightfully found to be confidential, who have said you can present them to the House. There is no authority whatsoever. We shall not respond to it. The good is Honorable Nyamira. You asked about the funds that are retained. Those funds are budgeted as personnel empowerment, and they're specifically to be used as such. You said you've been here the longest. I believe this has not passed you for all this time, but you have a chance to look at it again. Honorable Nyamira, you gave a very weighty statement on the floor of the House, saying that the Gazette notice that was presented came from Kiambu County. Kindly present the Gazette notice from Kiambu County. You didn't. Again, hearsay, feelings, innuendos. This is a house of law, not what I think, but what the law says. I will not respond to it. The issue of municipality boards, they have not been submitted. So the claim that the governor has submitted them stands, it's just hanging in the air. It has no legal basis. I will come to the issue of Paris. The issue of resubmission, Mr. Speaker, sir, came after the judgment of the court in Bomet on June 4th. He wouldn't have done it before. And there is a letter from this court, which I was referred to, I cannot recall who the honorable member raised it. But the reason for resubmission was not because he deemed or he acknowledges that the county machinery affairs were illegal. Not at all. It's as a result, again, following court orders. This is a judgment of the court, which the governor has followed to the letter. Mr. Speaker, just 2 minutes to address the issue raised by my senior on the monies. The monies was 2.8 2.3, personal enrichment. You know, my senior has selectively read and interpreted the letter from ESCC. Sorry, just excuse me, I'm trying to. The letter from ESCC 11A directing the governor to refund pending conclusion. The reason why the governor wrote to find the status is because he has a letter addressed to him saying refund pending conclusion. You know, Mr. Speaker, we pointed out before you that not all wrongs are clear and outright violations of the law. There is no submission whatsoever before this house showing how the governor directed anybody to pay him. Nothing whatsoever. He's been asked about this. He's gone before the ESCC. They've had alternative dispute resolution. He has refunded to the last penny. Because he's been told what you earn, you shouldn't have earned. It's not been shown that what you earn, you asked for. It's not his doing. It's not
Order, Honorable Nyamira, order.
Mr. Speaker, maybe sometime you will retain us to come and do the bono, because my senior probably has not done it. When you receive and take back, that even takes up your integrity. He's the one the governor has written to ESCC. He's taken part in ADR. He has refunded the money. Mr. Speaker, sir, then what is before this house? This is the third time, or second time, this issue is coming up in an impeachment motion. It's been put here probably to give it political mileage, which it lacks. It's standing on straws. It cannot be sustained.
Thank you.
Finally. Again, I will just point it out to the House. I hope my senior doesn't find this as a lie, but it's in the Constitution. The Constitution that says in the definition of gross violation, the Constitution has been laid out in the Constitution. It's not every violation or breach of the Constitution that can lead to the removal of a governor or deputy governor. Only a grave violation can lead to the removal. It must be substantial. None of these has been substantial. It must be serious. None of these are serious. It must be weighty. They are hanging in the air. They are not weighty. They cannot stand themselves. There is no clear violation or breach of the Constitution. Thank you.
Thank you. I now give the move of the motion.
Mr. Speaker, sorry, just for that one.
Order.
My apologies. Just be kind the last time. You're not going to ask for your
Proceed.
The issue of bribery has been raised.
Order, it was withdrawn.
Which was the
Order, it was withdrawn and it's not within our answer. So once one has withdrawn and apologized, it is done. I now call upon the move of the motion to Libra. Thank you. Proceed.
Honorable Speaker, sir, I stand to still inform members of this House that the allegations that have been pointed out are weighty, and therefore they need the action of this House, whose members have been said to be well endowed in various issues, including their academic backgrounds. Honorable Speaker, allow me to pinpoint Article 170, which was on gross violation of the Constitution of Kenya 2010 and the County Governments Act by failing to submit annual reports and deliver an annual state of account address to the County Assembly for 2 consecutive years. Going through the response, Mr. Speaker, one realizes that all that has been talked about here is quarterly reports. But we were talking about annual state of the account address, which ought to be done yearly, annually. Even the head of state, just about a week ago, a couple of days ago, had that annual event of State of the Nation address. Here, the government has never done the same for the last 2 consecutive years. And the councils for the governor are telling us this is not a crime. Honorable Speaker and honorable members of the August House, we have done our part. This is the 3rd time we have come back to this same house to beseech the members of this house to crack the whip and send the governor home because he has failed to live up to the expectations of the people of Nyamira. I once again beseech this house members that he should judge you harshly. The facts are on the table. We do not need to bang tables so that we can prove this. We have done our best, and may God be our judge and our witness. I rest my case and implore members of this house to do the necessary. Thank you, Mr. Speaker.
Members, I now put the question that this county assembly approves the removal of His Excellency Honorable Amos Nyaribo, Governor of Nyamira County, from office by way of impeachment on the following grounds. 1. Gross violation of the Constitution of Kenya and other laws. 2. Abuse of office. Honourable members, I will invite you to stand in order. Number 67. Unless, what is it, leader of majority?
Honourable Speaker,
You are up on standing on
point of order.
point of order.
Yes.
Proceed.
Honourable Speaker, I'm standing on standing order number 67, subsection 3, that notwithstanding paragraph 2 above, the Speaker may, in exceptional circumstances, and on a request per member, allow the voting be done through secret ballot. Honourable Speaker, I request that the next exercise, which is voting, be done through secret ballot. Thank you, Mr. Speaker.
Thank you. I was inviting you to the same standing order, read from number 1, unless otherwise provided under the Constitution or any other written law. A question arising in the county assembly shall be decided by a majority of the members in the county assembly present and voting. In ascertaining the results of a question under paragraph 1, the speaker shall, in the first instance, collect the voices of the ayes and the noes, and shall declare the results accordingly. Honorable members, I will also invite you to County Government Act, Section 33(2), and our standing orders 62, and then, because the speaker will not be able to ascertain the number of ayes and nays by the voice, then I invoke standing order number 1 and then accord the request put by the leader of majority to vote by sacred arrows. Office of the Speaker, Office of the Clerk. On the same note, Office of the Speaker is in receipt. On the same note, Office of the Speaker is in receipt of a communication from 5 honorable members. The Honorable Emmanuel Nyamira notifying the Speaker that he will not be in today and he doesn't intend to participate in the said motion. As you know, Honorable Emmanuel Kisesa is a member of UPA and the chair of United Progressive Alliance. 2, the Office of the Speaker, through the Office of the Leader Majority, has 4 letters in the file notifying the Office of the Speaker to accord them a chance to vote by proxies. I therefore invoke standing order number 1 and call the one leader of majority, the Honorable Leader of Majority, the Honorable George Abuga, to pronounce the names as read in that file and letters.
Thank you, Honourable Speaker.
I now wish to excuse. Resume your seat. I now wish to excuse the councils for the governor to take a leave, to allow the county assembly to proceed. Your work is done. We appreciate and may God bless you. Honorable George Abuga, as they take a leave, pronounce the names. Kindly save us time. Sergeant Attorney's Office, assist the councils. Thank you. Thank you. Thank you. Service of the clerk, as we proceed, organize. Honorable Leader of Majority.
Thank you, Honourable Speaker. Honourable Speaker, we are in receipt of a letter from Honorable
Honorable Amos, I also wish to invite you to Standing Order 67-4. On a question proposed for the decision in the County Assembly, the Speaker has no vote.
Madam Speaker, we shall call the names of the honorable members in order of seniority to come forward and pick the ballot, mark it, and cast it. So we'll start with number one, the Honorable Mavera Arbayo Gresa. Number two, the Honorable Abuga Church Morara. You come and pick the ballot, and you cast it after marking. We are reminded that we need to open this casting box to show the members of the public that it is empty. As that is being done, please call upon the Honorable Uganda Charles Nyaribo. Then as the guest, Honorable Masira Duke Oyagi. Then as it has been done, Honorable Mose Apel Mataya. The Honorable Chaki James Martina. by the Honorable Nyanduko Abigail Matini. Followed by the Honorable Makani Chalia Perudo. The Honorable Nyamira Kenneth Atuti. Followed by the Honorable Nyagana Julius Obonyo. Followed by the Honorable Venetia Thomas Vincent.
Order. Order. We need decorum yourself. What do you have on your on the hand? Thank you. Samuel Yogeto is here appointed. Okay, proceed.
Thank you, Honorable Venetia Thomas Vincent. Pick the ballot and then Honorable Kisesa Emmanuel Nyambega. Honorable Kisesa Emmanuel Nyambega. The Honorable Manuel Josiah Obegi. Followed by the Honorable Matwelo Julius Kimobi. Then followed by the Honorable Minda Ruben Riach. Then followed by Honorable Nyangao Cholo Mbongi. Then Honorable Ogwaya Henry Zinyo. Then Honorable Ogeto Sama. And followed by Honorable Square Alana Kinyakenga. Followed by Honorable Abel Elijah Sawe.
Honorable.
Followed by Honorable Atunga Joseph. To be followed by Honorable Evans Chuma Matunda. To to be followed by Honorable Matundura Spora Kerubo. To be followed by Honorable Maro Maka Kerubo. Then Honorable Mokora Priscilla Nyatichi. Then Honorable Musiere Lydia Nyaboke. To be followed by Honorable Nakuri Chenos Navula. To be followed by Honorable Nyamanga Doris Mogoma.
Order, honorable members, order. I expected that silence as voting is ongoing. Kindly.
To be followed by Honorable Bara Medina.
Proceed.
And to be followed by Honorable Onyancha Beatrice Kerubo. Then to be followed by the Honorable Omoya Michelle Kimuna. Then the Honorable Kupande Brian Mukaya. That is the end of the casting of the votes. Honorable Speaker, we wish to do the elections again.
Thank you. Any member left out, not called on the roll call, and is present or she is present. Now we wish to go to the county clerk, guidance, please of the clerk. Ensure the table is clear, no any other paper that should be near there. Subject of town's office, you clear from this one? 2 meters away. Clerk.
We are starting the exercise of counting. We'll start fast, then we'll start counting.
Order. What are you sorting? We need to know the total number of the votes cast first, and then sort the votes. If it is a yes, yes. If it is a no, a no. Order.
1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, 20, 21, 22, 23. 23 votes cast. Now we want to sort the yeas and the noes.
Order. You display.
This yes. 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 Say yes. Say yes. 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 Say yes. Yes. Say yes. Yes. Say yes. Yes. Say yes. 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 Yes.
Order. Honorable members, order. Order.
Now we are counting the number of yeses. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18,
Order.
19,
Go back.
20.
Order. Go back. Nobody is allowed to get into the house until the voting is over.
21,
Sergeant at arms, ensure that the door is closed.
22, 23.
Office of the clerk, you announce the results.
Total number of members in chambers. Yes, 23. No, 0. abstain 0, total number of valid and votes cast 23.
Honourable members, in standing order number 67-5, it says, in determining the number of members of the County Assembly for the purpose of voting, the Speaker shall not be counted as a member. Honourable members, also in standing order number 68-5, a member who is not able to cast his vote or her vote due to any reason considered sufficient by the Speaker may, before the results of a division is announced, and after obtaining the permission of the Speaker, have his or her vote recorded further by stating whether he or she is in favor or against. Is there any member who is committed elsewhere and wishes to vote? Thank you. Honourable members, honourable members, I now wish to announce the results as received. Total number of the votes cast 23. Yes votes that who voted for the yes 23. No votes 0. Abstain 0. Total number of valid votes cast 23. Members and the threshold of impeachment of the governor is 2/3. And this, in this case, the 2/3 of the total numbers of the County Assembly is 21.1. But there is no half a percent. As per the votes cast here, 23. Honourable members, the report on the removal of His Excellency Honourable Nyaribo, the Governor of Nyamira County, from office by way of impeachment has now carried the day. Honourable members, His Excellency Honourable Amos Nyaribo, the Governor of Nyamira County, now stands impeached. as guided by the standing orders. Now the office of the Speaker shall notify the office of the Speaker of the Senate for the necessary processing. Thank you. Next order.
Adjournment.
Order. Order, honorable members. Honorable members,
Mwasiara imemna wasacha. Nina wasacha. Ime. Ime. Ime ime ime. Ime ime ime.